website with concerning employment issues and various other issues. If you haven't taken a look at the articles we published, they not only include employment issues, but other issues that are affecting everybody now during this COVID-19 pandemic we're all facing. This issue today that we're dealing with misclassification of employees is front and center on everybody's mind, even before this COVID-19 outbreak. And it's something that is misunderstood greatly, and the law has changed dramatically in the past few months. Garett's going to go through the PowerPoint with you. We'll pick up with some questions and answers at the end of this. But the misclassification of employees is a very, very, very serious situation. You'll learn that it affects many companies. There's a lot of new laws that are trying to be enacted to change effects of two things. You may have heard about a recent enactment of a statute called AB 5. You may have heard about a case called Dynamex. And that case and other cases related to it, as well as the enactment of AB 5, significantly change how workers are classified. And there's a lot of implications as a result of misclassification, not only for penalties, attorney's fees and litigation, tax issues, and other things like that. So with that, I'm going to turn this over to Garett, let him go through the PowerPoint presentation, and I'll chime in when necessary, and we'll pick up with some questions at the end of this. Garett?
Cool. Thanks, Jeff, and thank you to all you guys for joining today. Hopefully you are seeing the overview slide that is up right now. So just kind of quickly, I'm going to run you through the presentation, as Jeff said, and we'll take some questions after. So we're going to start really talking about why proper worker classification matters. You know, there's a couple areas of law where the importance of proper classification really shows itself. And obviously there are, you know, steep penalties that can result from misclassification. So once we go through that, then we're going to talk about how to properly classify. We'll talk about the old test in California and the new text as put out by the Dynamex case that Jeff mentioned. And then we'll go through AB 5, the statute that was codified. Dynamex took effect at the beginning of this year. And we will also talk about some kind of open-ended questions and sort of how these interpretation of all these tests and different frameworks are sort of still kind of unfolding. So with that, we will start talking about one area of the law that really, as I mentioned, kind of shows how important proper classification is, and that is the California wage orders. So the California wage orders, also referred to as the Industrial Welfare Commission orders, as the IWC issued them. There are 17 of them, and they apply to specific industries. And while, you know, the orders differ given the specific industry that the individual order applies to, there are, you know, various overlapping and similarities between them. In essence, these orders really just require employers to provide certain benefits and protections to employees related to kind of working place related conditions. And critically, independent contractors are not eligible or entitled to these protections. So what are these protections? I've listed some of them here. Minimum wage, overtime pay, paid time off, meal breaks, vacation time, reporting time pay, which in California is when an employee is told to report for work, either by calling in or showing up for a shift and the services aren't ultimately needed, that employee is still entitled to between 2 and 4 hours of pay. So these protections, like I said, apply to pretty much to each order and in each industry that the order applies to. I do want to make the point that certain employees are exempt under these wage orders, and you might just think, you know, if you're a salaried employee, you're not entitled to overtime. And while that is usually the case, the orders themselves actually look to the responsibilities of the employee, is their independent discretion being exercised, and whether that employee makes over 2 times minimum wage in a given month. So clearly, you know, it's important for employers to, you know who are their employees and who they need to provide these protections to. So a second area of law that really shows the importance of proper worker classification are the tax obligations imputed to an employer. So for example, I've listed some of them here. An employer is responsible for withholding an employee's state and federal income tax, Social Security and Medicare, various contributions to state required taxes like disability insurance, unemployment insurance, employment training, and any other applicable payroll taxes that either mandated by the state or perhaps the county that the business operates in. I also want to make the point too, real quick, and this isn't on the slide, but the federal framework, which we're not going to really get into today, as far as the federal test for classifying employees, is very different from that of California's. The federal framework uses an economic realities test. So with that said, without getting into the details of the test, there can be instances where a worker is properly classified as an employee under California, but for federal purposes remains an independent contractor. And so businesses kind of have the option, or they can have the option in this scenario, to treat workers differently for those different purposes. Jeff and I aren't tax attorneys, so if that's something that you would be interested in, we would suggest consulting with a tax specialist. Also want to note that under the Unemployment Insurance Code, specifically Section 1735, there can be personal liability for failure to properly pay the amount of contributions and withholdings due as a result of a misclassification. This section requires that the person having charge of the affairs of the company for making these tax obligations must fail to contribute willfully. So there is an affirmative defense potential there for, perhaps negligent or accidental failing to make withholdings or contributions, but nonetheless there is that possibility. So again, this is just kind of another area where proper worker classification is very important. And in addition to this Unemployment Insurance Code section, which can impose liability on, obviously the company as well as the individual responsible for making these withholdings and contributions, there are a litany of other various methods of enforcement and remedies and potential liabilities that can result from misclassification. So we'll talk about that on this slide. So the most common scenario we usually see play out is you have a worker who feels as though he or she has been misclassified and asserts a claim for benefits due under the wage orders had they been properly classified. So usually any wages due or other benefits that were owed, and they will tack on interest and potentially attorney's fees to these awards as well. And this lends itself to big class action awards where similarly situated workers, especially for big companies, can all join in, and it leads to large awards that also include attorney's fees. So there's also a public right of enforcement whereby the labor commissioner can assert misclassification claims against a company on behalf of the state via the Private Attorney General's Act. I believe in these instances, usually 75% of what's recovered goes to the state and 25% will go to the actual individual worker who is misclassified. And also AB5, which we're going to get into in a few slides here, also allows big cities with populations of over 750,000 to enforce misclassification as well. So there are also various civil penalties available for misclassification under the California Labor Code. I've listed a couple of them here. Section 558 imposes basically a strict liability, $50 for your first misclassification violation, $100 for each subsequent. There's a bill pending right now, actually SB 1331, that would increase these amounts to $125 and $250. And a related section 558.1, just similar to the Unemployment Insurance Code section we talked about on the previous slide, related to taxes, can impose these violations and fines on an individual who is acting on behalf of the employer. So more worrisome is section 226.8, which will impose between $5,000 and $15,000 for a violation of a willful misclassification. Now, willful misclassification is defined as knowingly and voluntarily misclassifying a worker to avoid employee status. So again, there's sort of a potential affirmative defense here that this wasn't done willfully, but nonetheless, these severe fines are possible. And these amounts can be even further increased to 10 and 25 to between 10 and 25,000 if there's a pattern of this willful misclassification found. And again, these penalties can be imposed on the person or individual who is engaging in such willful misclassification. So there's also criminal sanctions available. Failure for misclassifying, failure to withhold and pay payroll taxes can result in a misdemeanor charge and even a jail sentence. There's other sections under the Unemployment Insurance Code that also provide criminal penalties. For instance, 11760 will impose up to $50,000 fine and up to 5 years in prison for any person who misclassifies workers in order to reduce the number of employees for the purposes of procuring workers' compensation insurance. So just suffices to say that there are a lot of potential routes for imposing liability as a result of misclassification, which include not only just civil penalties but also criminal sanctions as well. There's also a cause of action under the Business and Professions Code for unfair business practices. Okay, so that kind of sums up our kind of overview as to why proper classification matters, as far as making sure you're compliant with the tax provisions and the wage orders and avoiding all of these potential liabilities. So let's get into now. Yeah, sorry.
Garett, hang on one second before we go to the next slide. I want everybody to understand that this area that we're talking about right now, this potential liability for misclassification, is really important to understand because a lot of litigation concerns the misclassification, and a lot more is going to come in the future with the enactment of AB 5 and the Dynamex case that Garett will be talking about. Not to mention there's potential attorney's fees that Garett touched on in the beginning, and back wages that have to be paid. But as Garett talked about briefly in the slide before, there is potential for individual liability for people that are responsible for making the payment. That's not the president necessarily or the managing member of the company. That could be a CFO. That could be a person writing the checks. That could be any person that is responsible for classifying the employee, and that person as an employee may have some defenses to that, which is another topic we can discuss. But understand that a claim could be brought against the responsible person, which is something that has been done in the past, but not so much as we're seeing now and we're expecting to see going forward. Go ahead.
Thanks, Jeff. And we'll touch on some other litigation involving, proper classification that's sort of ongoing in later slides. But again, so that kind of sums up why, classification is really important. So let's move on to now how to properly classify. So for a long time in California, the operative test for classifying independent contractors from employees was referred to as Borello. Borello is still in use, so it is still relevant. We'll talk about how in a couple slides, but the Borello test really focused on the degree of control that a company either asserts or could assert over all aspects of the work performed by the worker in question. And it does start with the presumption that workers are employees, but it allows the employer to rebut this presumption by pointing to a long list of various factors that sort of tend to indicate whether control is being exerted. So what are these factors? They range from how much skill is required in the performance of the work, who's providing the instrumentalities and supplies, who owns the property where the work is being performed, who's making the calls on the important decisions of the performance of the work, and what do the parties actually believe their relationship to be. So there's additional factors beyond that, but there's none of these factors are really dispositive, and it sort of created this gray area and this uncertainty as to how many factors employers needed to show in order to satisfy this test and to thus show that their workers are properly classified as ICs. And we'll get to this in a second, but the Dynamex court in 2018 really thought that this test was sort of creating a competitive advantage for businesses who are not properly classifying, just given the flexibility of this test. And these businesses just pointing to a few different factors that might be favorable to them and sort of ignoring the ones that weren't, and sort of were skating by through the flexibility of this test. So fast forward now to 2018 and the Dynamex decision, which introduced this new test. And again, the Supreme Court wanted a more concrete framework where both workers and employers would have a better idea of how they should be classified, as opposed to this kind of gray area that the Borello test created. So the Dynamex test, like Borello, also starts with the presumption that all workers are employees. However, it requires employers to prove 3 separate prongs in order to rebut that presumption and thereby prove that their worker is properly classified as an IC. And failure to demonstrate any one of these prongs necessarily results in a finding of employment status. So you have to satisfy all 3 of these, or else the worker is deemed an employee. So what are these prongs? The first prong is essentially the Borello test, that the worker is free from the control and direction of the hirer. A lot of the same factors that I just mentioned on the last slide are relevant for this prong. But again, this is just one part of the 3-part test that employers must now get over. So prong B is definitely the most controversial. A lot of businesses that could pass Borello that now can't pass Dynamex. Prong B is the reason why. Prong B requires that the worker performs work that is outside the usual course of the hiring entity's business. So the kind of straightforward example that the Dynamex court provides is if you consider like a retail clothing store that makes and sells clothes. If they bring in a plumber to fix a leak, clearly the plumber is not performing a function within the usual course of the hiring entity's business. But say the same store, hires seamstresses to make clothes, and say the seamstresses work from home and they choose their own hours and use their own sewing equipment. Under Borello, there'd be very little control being exerted over these seamstresses, and they'd likely be considered independent contractors. But here, under the Dynamex test, they would not be able to get around prong B and would likely be classified as employees. So prong C is that the worker is engaged in an independently established trade or business of the same nature as that involved in the work performed. This has also been interpreted as whether the class of this type of worker is customarily engaged in its own independent business. So again, those are the 3 prongs, and failure to prove any one of them will result in a finding of employee status.
Let me chime in on something here, Garrett, please. I want everybody to understand that there's a presumption under Dynamex, as the first line of the slides indicate, that all employees are, all workers are employees that you're paying. So in reality, what happens is if you have these 3 prongs, and if you can establish all 3 of these elements, then the presumption goes away. So you have to understand that you're starting from the premise that anybody that you employ within your business, anybody that works for you, is an employee. And these 3 prongs make it very, very difficult for companies, even in the gig economy, companies that are where you have programmers that are writing code that work for you in the company, where you're directing them. Part of your business is to program a particular application, and the employee is not engaged in an independent established trade. These are all going to be employees, even if you call them independent contractors and pay them on a 1099. You don't get around this.
Yeah, just to add a little bit to that, Jeff, so you mentioned the gig economy. This test and AB5 were in part really designed to force the gig economy to reclassify their workers as employees, and that's largely because of prong B. Now we've seen major gig economy companies like Grubhub and Uber already kind of put forth these arguments that are trying to define themselves in a broad sense as just a technology platform that just connects users, as opposed to a transportation company or a food delivery service, and that's largely for the purpose of, trying to buttress this argument that their workers fall outside the usual course of their business. We haven't seen these arguments play out in court yet, but they have been received with some skepticism, so that's something we'll keep our eye on. A couple other quick points about Dynamex.
Garett, if I can interrupt real quick.
Sure.
We got a couple questions here. Number one is someone would like more of an explanation on point C, the third bullet.
Sure. So, Part C requires that the independent business, that the worker has some sort of independent business ongoing that is in the same nature of the service that's being performed. The independent business operation must actually be in existence at the time the work is performed. The fact that it could come into existence in the future is usually not sufficient.
Let me chime in as well, Garett.
Yeah,
on the independent established trade, let's go back to my quick example about a programmer. If you had a programmer that's working outside of the company that does programming for other people as well, not only for you, and he's got a business, like he's got his own company, and his company is involved in programming, then you can establish that he's an independent trade. But if you have programmers that work for your company full-time and they're doing programming, and they may be in different locations, they don't have to be in the same place, that person is likely going to be an employee because it's not independently established business of the employer, number one. And number two, it probably doesn't meet Part B, which is the most difficult, because if your usual course of business is programming, you may not be able to meet that test. So you've got to look at somebody that is, if you pictured a separate business and that person works for a number of different people, even though it's programming, and he can do that work separately and independently, he's probably not going to be an employee and will probably be able to meet that test. I hope that answers the question.
So Jeff, that dovetails into the next question is, what if person working has a corporation, whether it's a C Corp, LLC, S Corp, and the company that is engaging with that person is paying their corporation, not that person. So say he's a programmer and he has a programming business, or say it's a part-time CFO that works for one of the myriad numbers of firms that provide CFO services.
If it's done as a subterfuge for an employee and he's only working for the one company and he's not working for others as well, he probably does not have an independently established trade or occupation. If that, now, there are different kinds of people we have to look at, which Garett's going to talk about, because there are some exceptions to the rule dealing with professionals and other types of employees that are exempt from the requirements of AB5 that Garett will get into. So there's more than just looking at Dynamex, although Dynamex is the precursor to AB5. AB5 is trying to explain what this is, and as I indicated, there are a lot of exceptions. And as you get into, let's get into AB5 and let's talk about that a little more. And then at the end, if we have more questions or they haven't been answered on this particular part of the subject, we can get into that further.
Okay. Yeah, we have a couple more questions, but let's get back to the presentation, and I'll tag these.
Okay, and just a couple more points quickly about Dynamex. The Supreme Court held that this test was only supposed to apply to wage order claims or claims brought by workers who felt as though they've been denied benefits under the wage orders that we talked about a few slides ago. As we'll talk about on the next slide, AB5 changes that, but that was the Supreme Court's intention. Also, this test is not applied in the joint employer context. So a couple cases coming after Dynamex held that where a worker tried to hold not only its direct employer liable for misclassification under the Dynamex test, it also tried to hold a related entity, whether it was his parent entity or just a company affiliated with his direct hire through franchise agreements. And those courts held that no, the Dynamex test only applies to the entity that hires you. So that's not to say that two separate companies that hire the same worker can be forced to satisfy the ABC test, but that's the joint employer exception. So now getting into AB5, as we've touched on, it is the California State Legislature bill that was introduced last year to codify the Dynamex decision. So AB5 both expands and narrows the ABC test application. It expands it in that it applies the ABC test to all claims brought under the labor and unemployment insurance codes, so not just wage order law claims. But it narrows it, as Jeff just touched on briefly, in that there are a lot of exemptions built into the bill and professions that, if they can satisfy the exemptions and the additional requirements incorporated into those exemptions, will remain governed under Borrello as opposed to the Dynamex test. So included some of the kind of policy reasons and drawbacks of the bill, obviously to reduce poverty, protect workers' rights, also generate tax revenue. When the bill was introduced, there was a report out that said something like $7 billion a year in payroll tax revenue was lost due to worker misclassification. So that was obviously a big intention behind the bill. Some of the drawbacks, which we're already kind of seeing play out in certain industries, especially, that it threatens workers' ability to maintain their flexible schedules and earn important supplemental income. And obviously, these reclassifying workers as employees is an additional cost for employers, so they have to deal with that added expense somehow, whether by passing that on to the consumer in the form of raised prices or just limiting the amount of hours and openings available, or just relocating work entirely to other states or countries. All right, so we touched on how there are exemptions in the bill. We're going to go through 4 of the main kind of broad categories of exemptions built into the bill right now. Also want to point out that if an employer is able to satisfy one of these exemptions, it doesn't necessarily mean that the worker is automatically an independent contractor. What it means is that the relationship will be classified under Borrello as opposed to Dynamex. So there are also other exemptions here that we're not going to get into. There's one for real estate and repossession agents, where that employment relationship is governed under a specific test in the Business Professions Code. And there's another one for the construction industry. But we're just going to focus on these 4 broad ones for our purposes. So the first exemption we're going to talk about is for licensed professionals. It's pretty straightforward. So if you are any one of these professions and are properly licensed in the state of California, then your employment relationship will be governed under Borrello as opposed to Dynamex. So you'll see a lot of healthcare professionals, doctors, surgeons, vets, lawyers, architects, and somehow commercial fishermen are on there as well.
Garett, is this in the code, or is this a summary, or are these actually delineated in the exemption?
These are delineated in the exemption under, I believe it's subdivision B of the bill. And it lists out all these various categories of licensed professionals that are qualify under this exemption.
And engineers, could that be, computer engineers, people who are doing code?
Yes, it could be if they're an engineer. And
They have to be licensed, right?
They have
yeah,
to
the
be
key
licensed,
is being licensed.
not just being a programmer.
Right.
Okay, so moving on to the next exemption, it's referred to as the professional services exemption. Now, this exemption is notable in that of the broad exemption categories that we're going to be discussing, that remain to be discussed, this is the only one that applies to individuals and not individuals operating through a business entity. So that was kind of brought up as far related to that prong C, but that is something that can be beneficial, being that you operate through some sort of business entity, either an LLC or sole proprietorship. Here, though, this exemption will apply to individuals and also those individuals operating through a business entity who provide professional services under contract and can meet certain requirements related to their independence. And it's also limited to specific industries, which we'll get into in a second. But what are these additional requirements? The individual must have a business location. It could be a home residence. The legislation gave a 6-month period to satisfy this next requirement, but starting in July, they must have a proper business license. There must be some ability to set and negotiate rates and to a lesser degree hours. And then these next 2 requirements, you'll see this as being a pattern in this and the next 2 exemptions we're going to discuss, where essentially prongs A and prong C of the Dynamex test are sort of built into these exemptions. So in essence, it's sort of a way of just getting around prong B. They're not identical to prongs A and C as stated in the Dynamex decision, but pretty similar in that a requirement of this exemption requires that the worker must hold themselves out for the same type of work with others and regular exercise discretion. So what are the industries that are where this exemption is available? I've listed them here. Marketing, HR, grant writing, graphic design, fine artistry. There are some special circumstances and even additional requirements in addition to the requirements listed above that need to be satisfied by certain of these professions. For instance, for marketing, the work must be original and creative in nature in order to qualify for this exemption. And what does that exactly mean? It's not really clear. I'm sure case law will shed some light on this eventually, but it does say that the work must depend primarily on the invention or imagination or talent of the worker. So similarly in HR, the work must be predominantly intellectual, cannot be standardized or over a given period of time. There's also an important caveat to the freelance photographers and journalists who try to make themselves avail themselves to this exemption, in that there is a cap as for 35 pieces of content that could be submitted to an individual employer. So for a freelance journalist to avail themselves to this exemption, they cannot submit more than 35 pieces of content to their employer. And we'll talk about how that provision is being challenged both in the courtroom and the legislature later. You also see graphic design, fine arts. What does that exactly mean? It's not really sure. It could be interpreted broad or narrow. And this last category here, these licensed estheticians, electrologists, manicurists, barbers, and cosmetologists, they have an additional set of requirements that they must meet, which include that they set their own rates, process their own payments, schedule their own appointments, among others. So there is a lot to consider here. If a worker or an employer is trying to make themselves compliant with this exemption, again, the important thing to note about this exemption is that it does apply to individuals and not just individuals operating through a business entity.
All right, let me point something out here to everybody. You're probably looking at this slide and going, boy, how did human resources and travel agents and fine artists get into the exemption for professional services? You need to keep in mind that when the legislature enacted AB 5, everybody had a hand and a comment to make regarding who should be excluded and who shouldn't be. Various groups and organizations got involved, and they said we should be excluded, or this one should be excluded, or that one should be excluded. So ultimately, in getting this bill passed, there are a lot of things in here that may not make sense, but that's our legislature. So with different pressure being put on various legislatures to deal with this, they got certain exemptions included within it. There's no rhyme or reason. If anybody's going to ask me, why is this one in here and that one isn't, we can't really give you an answer that makes any sense, because there is no sense to it. This is just what was passed. And there's a lot going on right now to get other groups into the exemption category. Okay.
Okay, so going on to the next exemption, which applies to service providers. And just like the professional services exemption, this exemption is also limited to the industries defined in that third bullet point. But also notably, as I mentioned on the last slide, this exemption only applies to businesses or individuals operating through a business entity. So individual workers cannot avail themselves to this. But again, this exemption applies to businesses referred to as service providers who contract with a referral agency to provide services to clients. So that's important to note that the services are being provided to the clients and not directly to the referral agency. So again, there are additional requirements for this exemption to be met. You'll see prongs A and C sort of replicated here and to some degree. Also, again, actually one big requirement here is that the service provider is delivering services under its name and not the referral agencies. I'll talk about a little bit more about that in a second. That the service provider provides its own tools, supplies, sets its own hours and terms without deduction from the referral agency, and is not penalized for rejecting clients provided by the referral agency. So if you take a look at the industries or the applicable services in that third bullet point, you might think, oh, could someone in the gig economy, avail themselves of this exemption? I see errands and furniture assembly, dog walking. I'm thinking, my Amazon grocery deliverer and TaskRabbit guy who helped set up my TV mount. Could those workers avail themselves to this exemption? And the answer to that question is likely not. And you'll see just by going through the requirements that, in addition to having to be operating through a business entity and not just in the individual sense, the services must also be provided under that entity's name and not, Amazon's or TaskRabbit's, which would likely not be the case. Okay, so the last exemption we're going to discuss here is the most broad in that it's not limited to specific industries. However, the additional requirements that need to be satisfied are perhaps the most stringent. So this exemption applies to business service providers that contract with contracting businesses that can meet these additional requirements. So again, we'll see prongs A and C sort of replicated here from the ABC test, although prong C, in addition to just being customarily engaged in an independent business of the same nature, the business service provider must actually contract with other businesses, must maintain its own clientele, and must advertise and hold itself out to the public. So it's a little different than the other exemptions. Other requirements that the contract be in writing, that there's an ability to negotiate their own rates. And again, this exemption applies to businesses who are providing services directly to the contracting business, not to the contracting business's customers, like that service provider referral agency exemption we just discussed on the previous slide. They must have a separate address and provide their own tools and vehicles and equipment. Also, I just want to note that this exemption does not apply to individuals who work for these business service providers that contract with the contracting business. This only applies to the relationship between those two businesses and not any individuals who work for them. Those relationships would be classified under Dynamex. Okay, next slide. So we're going to talk about, a couple just sort of open-ended things that are sort of ongoing, some open questions, one of which is retroactivity, and whether these tests will apply retroactively, to work performed in periods before these tests were introduced. So AB 5 is explicitly not retroactive. It has a provision that states it only applies to work performed on or after January 1, 2020, when the bill became effective. However, there is a provision that allows the exemptions to apply retroactively, and in order to basically shield employers from liability if they can avail themselves to an exemption. So it applies to existing claims and actions to the maximum extent permitted by law. Now, what are existing claims and action? Does that mean claims that have already been filed or claims that have just arisen or could be filed? It's sort of unclear. And it's also unclear what the maximum extent permitted by law means in this context. So more importantly, Dynamex is silent on the issue of retroactivity. And we had a case come in the Ninth Circuit about a year or so after Dynamex in May of last year that held that that Dynamex should be interpreted retroactively. And their reasoning was that it was more of a clarification as opposed to a departure from established law. So, under this holding, even if a worker performed services entirely prior to when the Dynamex decision was issued, the ABC test would still govern the dispute for periods of up to 3 or 4 years, depending on the specific claim that was brought. So obviously, businesses were not happy about this. They felt that it was unfair to be subjected to a test for periods of time before it had been introduced. And the Ninth Circuit, sort of feeling the heat on that, withdrew its decision of retroactivity in July and sought certification on just this narrow issue of retroactivity in November from the California Supreme Court. So we're expecting a ruling on that issue, fairly soon. But even if there is a retroactivity holding by the Supreme Court, it is likely that that would only extend to the Dynamex decision, which again only applied to wage order law claims. So it's likely that any retroactive application would be limited in the sense that it would only apply to the Dynamex decision, which again only extends to wage order law claims. Okay, so Jeff had kind of touched on how there's still a lot of pending litigation and challenges being waged at AB5. I'm going to talk about a few of those now. So these are just some of the main cases going on challenging AB5 in some way or another. The top 2 cases brought by the Trucking Association and Olson v. California are both examples of where workers in an industry said, we like being independent contractors, don't enforce this ABC test on us, basically leave us alone. So while the trucking industry had some success in this arena, and on the grounds of a preemption argument, i.e. that AB5 was preempted by the Federal Aviation Administration Authorization Act. And there, the Trucking Association got an injunction granted and extended in federal court, and just got an outright order in state court that they are AB5 is enjoined from enforcement in their industry. So the trucking industry looks to be basically has created a case law exemption for themselves. Less successful have been the other 2 cases. Olson involved Postmates and Uber drivers who again asserted that, leave us alone. We want to remain independent contractors. We don't want to have to satisfy the ABC test or be reclassified as employees. And the companies obviously joined in on that case as well. The argument there was one of due process. And Jeff kind of touched on this argument earlier that, the exempted professions in the bill were just chosen arbitrarily, i.e. there was no rational basis for deciding who was exempt and who wasn't. And there, the federal court ruled in denying a preliminary injunction that the state's interest in policing misclassification outweighs any potential harm that could be suffered. So that case is proceeding on to the merits. So we'll keep an eye on how that case develops. Also, and I touched on this earlier again, the American Society of Journalists have asserted a case on behalf of freelance journalists and photographers, essentially challenging that 35 submission caveat to the professional services exemption, which freelance journalists and photographers are encompassed by. And the argument there was that this impedes on their First Amendment rights. It's an impediment to their freedom of speech. And similar to Olson, the federal court there also denied a preliminary injunction. But again, this case will also be proceeding, so we'll keep our eye on that. So in addition to these challenges in the courtroom, we're also seeing a lot of proposed legislation that has been proposed since AB5 to sort of counteract the bill in one way or another. So these top 4 bills on this slide here essentially either seek to alter an exemption or create a new exemption. 868, as we've discussed, seeks to eliminate the 35 submission cap for freelancers. 875 looks to create an exemption for interpreters and translators and court reporters. 881 seeks to create an exemption for the music industry. And 1925 also actually seeks to create an exemption for small businesses defined as independently owned and operated businesses with fewer than 100 employees and less than average gross receipts of 15 million over the previous 3 years. SB 1039 is interesting. It doesn't really do anything right away, but what it sets out to do is develop a third classification of workers that sort of splits the difference between an independent contractor and an employee, where you'd have, you know, the sort of flexibility and freedom to create their own schedules that independent contractors enjoy, but would be granted some of the protections and benefits like minimum wage and overtime that employees enjoy. So that is something, again, we'll keep an eye on as its developments are ongoing. And lastly, AB 1928 just basically seeks to overturn AB 5 in its entirety. And, you know, similar to the potential retroactivity holding by the California Supreme Court of Dynamex and its unlikelihood of affecting AB 5, AB 1928 would overturn AB 5, and it's, you know, it's unlikely that this would have any effect on the Dynamex decision itself, but it's unclear, you know, exactly what effect it would have until when and until that bill is passed, or if and when, I should say.
Let me just say one thing. It's also unlikely that AB 1928, in my opinion, is going to pass.
Right.
Given the fact that AB 5 was enacted, I don't think they'll have enough votes to overturn it entirely. So I wouldn't be holding my breath for that to get
Jeff,
passed.
do you think with the current scenario, COVID-19 and people being out of work and wanting to get people to work as quick as possible, that maybe that's a crack in the ice there?
You know, and it might possibly be, but, you know, a lot of this is driven by financial interests. States want to get certain revenues in. They want workers to get coverage for unemployment, Social Security. So I'm not sure. It may give some opening to that, but just like the Uber driver and Postmates drivers and Lyft drivers, it's a very hard concept to change within the legislature to just all of a sudden allow for this opening. And again, as Garett mentioned, the fact is while the statute AB 5 may be overturned, unless the Supreme Court overturns Dynamex, okay, then we're still going to be left with that court decision, which says almost the same thing that AB 5 says without the exemptions. And it really won't do away with the law in California, even if they decided to change that. Now, the only way it's going to change anything is if the legislature comes out and says, you know, as a result of the current public emergency, you know, we see a need for allowing independent contractors. I just don't see that really happening, because you can still be an employee and work out of your house. You can still be an employee and drive a car. Uber and Lyft are a little different situations. They're trying to take the position in their court case that they are not really a ride-sharing company, but in fact, they are an application that allows people to connect, and they don't really provide ride shares. They just have this interconnected program that allows people to be able to pick up rides and do their thing. We don't know how that's coming out, but that's going to be up before the Supreme Court as well.
And just to add a wrinkle to that, Jeff, there have been a couple like emergency motions or proceedings brought by specifically drivers of Lyft and Uber seeking to be immediately reclassified as employees so that they would qualify for the paid sick leave, either under the recent Families First Corona Response Act or just state-provided paid sick leave. In one of those cases, I believe it was the Lyft case, the federal court there denied the emergency motion for sort of procedural matters, but it did say, you know, that drivers are likely to be reclassified under AB 5, but it stopped short of doing so in the immediate fashion that was asked. So, you know, we are seeing requests, you know, based on COVID-19 and this emergency situation to, you know, be reclassified in order to qualify for paid sick leave, but I haven't seen that actually be granted.
All right, this might be a good time for a question that somebody asked. How does this impact companies that are virtual, where there's no brick and mortar, where everybody's virtual, working from home offices, does that change the control issue of employers on potential employees or ICs?
No, brick and mortar is not the defining factor. Having an office, having everybody in one location is not the deciding factor. You can be an employee, be classified as an employee and you will be classified as an employee under AB5 in California if you don't meet, if you don't meet the tests, the ABC test.
Sure.
Now, there's another complication that we haven't mentioned. What if you have a company that has people employed all over the country, or people that are doing work for them all over the country?
Or the world.
Or the world, for that matter. How are they affected? Well, obviously, AB5 only applies to California employees. So different states may have different laws, but California may come along, and we haven't seen that says, wait a second, what's going to happen with an employee that works outside of California, and how are they going to be treated for purposes of withholding? You're going to have to look at that particular state's statute on how they're classified as an employee, or in some cases, maybe federal law. So the brick and mortar, to answer the question simply, the brick and mortar is not a deciding factor.
Okay, thank you. And that then brings up the case of people who are using programmers to code, who are outside the state of California, whether they're in Poland or in Guatemala, or if they're in Nevada. And I guess you answered the first part. For overseas work, is there something in particular people should watch out for?
Well, we don't know if California is going to try to extend jurisdiction to those employees and say they work for a California company. We haven't seen anything. Garrett, I haven't seen anything on that at this juncture. Have you?
No, I haven't either. And as far as I know, AB5 and just the labor code in general applies to work being performed within the state. So even if you're a California resident and you're performing work outside of California, that wouldn't apply. It's only to work performed within the state.
Oh, interesting. Okay. Thank you for that clarification. Sorry to interrupt.
No problem.
No worries. We're pretty much done here. Just kind of a bit of a wrap-up slide and things to just sort of consider going forward. If you are a business owner or if you're an employer, you should really, if you haven't done so already, immediately determine if any of your workers have been misclassified. And if you find that someone perhaps has been misclassified, you should immediately determine what action needs to be taken to avoid any penalties or liabilities. Now, normally this might include just reclassifying an IC as an employee and providing any back pay or compensation owed, or making any rectifying any tax obligations or contributions. Also, just given this open-ended retroactivity question, it would probably be wise to evaluate your classification practices for the previous 4 years, because that's how far back these claims could extend, in order to determine your maximum potential liability, at least as applied to the wage order law claims, assuming that a California Supreme Court holding of retroactivity of Dynamex only applies to Dynamex. But even if Dynamex is not determined to be retroactive, the ABC test would still apply to wage order law claims going back from the date of the Dynamex decision, which I believe was April 30th of 2018. So the ABC test could apply, before AB5 was became effective, if they're wage order law claims that cover, from the date of Dynamex decision onward.
I had a quick question, a couple questions. One, someone wrote, does SB 881 cover all types of live entertainers booked for events, possibly only one time in a calendar year?
So I'm not exactly sure. I don't think that exemption has that level of detail. I'd have to go back and read the actual text of that bill to give a sufficient answer, but I'm not entirely clear. I do know that there had been some commentary on this bill, suggesting that it was sort of ambiguous as to what music industry professional really means. But other than that, I'm not entirely sure. I'd have to look at the actual text and get back to it.
And then as far as complaints being brought forward, can third parties make a complaint to the State Labor Board, or is it just the employee that is able to make a complaint on behalf of themselves for a wage order law claim?
I'm not sure why a third party would be making a claim. They wouldn't have a claim.
A competitor?
Competitors have been known to notify the Department of Labor of wage order violations, overtime violations. In some sense, sometimes I've seen it for misclassifications over the years, but really not a lot. They can make a claim. The fact is that the Department of Labor is likely not going to investigate a claim made by a third party. I don't see any basis for it. It's really, this test is to protect the employee, and it's for claims brought by the employee, not some third party to get some benefit, as you would say. So I've only seen it a couple times over the years in overtime, failure to pay overtime and whatnot for piece good workers in the garment business, where one garment company is trying to get an advantage. I've never seen it in any other context.
So from a practical standpoint, if someone is, quote, an independent contractor providing service to a company and both parties are happy, even though they may be misclassified, obviously the liability is on the company, but if there's an agreement between the two to have that working relationship,
yeah, that doesn't matter. An agreement to be defined as an independent contractor is irrelevant for purposes of having to satisfy the ABC test if you actually have to.
But only relevant if someone brings up a claim.
No, it won't do anything for you. A lot of agreements have been written over the years, independent contractor agreements, where they say you're an independent contractor, you're going to pay your own taxes, you're going to pay your own, you're going to withholdings. It's your responsibility to do that. You're going to hold us liable in the event that any claim is made, et cetera, et cetera. Not going to be enforced at all. Okay, if you meet this test and if you're an employee and you cannot meet the test of being an independent contractor, I don't care what your agreement says. It will not hold up. It's against public policy. It's a violation of the law. And do not expect for 1 second that any agreement that you have with an employee to treat them as an independent contractor because they say, we want to pay our own taxes, we'll take care of it. That is not going to protect you in the event there's a claim. And I want to also explain that you have to understand, when everybody is getting along and everything is fine and the worker's getting paid and they're getting the money they want, no one's going to probably talk about it. It's when things go bad. And this part of misclassifying people that we're trying to talk to you about today is about dealing with what happens when they go bad. And when they go bad, they're going to go bad big time and in a very expensive way. And in a way that you're not going to believe what could possibly happen in terms of legal fees in cases, interest that could be due, the potential for retroactive application, if that passes. And the sheer fact of the matter is it's going to be, it can be so expensive, obviously depending on the number of employees and how long you've been doing it, that you're going to really wish that you had done this differently. And when lawyers sink their teeth into this in class actions that I've been involved in and a lot of wage cases that we deal with, they don't let up, especially if they think that they can get attorney's fees at the end of this whole thing. So I'm cautioning everybody, do not think you can enter into an agreement and it's going to protect you. Do not think an indemnity is going to get you out of your liability Do not think that you have an understanding because your friend is okay with being a independent contractor. When that changes, and believe me, it changes all the time. Somebody gets fired, somebody gets laid off. First thing they're gonna do is they're gonna go for unemployment. When they find out they don't have it, claims are gonna get made, and they're gonna find a lawyer.
Okay, very good.
Before we get off, I would like to say one other thing. This retroactive application of this is very problematic and very concerning, and should be concerning to everybody that is classified employees as independent contractors. The fact that AB5 is not retroactive doesn't mean that Dynamex is not retroactive. The fact is that the Vasquez case may come down, and it may say Dynamex should not be retroactive. I actually believe that it's going to come down, and they're going to hold that Dynamex is retroactive. And I think that's going to be very bad, because I agree that it's just an interpretation of the existing law. And if I'm wrong, great. But if I'm right, the potential damages can be tremendous, because you go back 3 or 4 years.
Thank you. Garrett?
Yeah, that's about it as far as what we have. Just kind of continue to.
Let me see if there's any questions then.
Yeah.
Folks, if you have questions, you can either unmute yourself, you have that ability, or you can type it into the chat and ask the question yourself. Anybody? I think I got everybody's questions as they were going along, so we were able to do that.
Mark, thank you for your comment. You be safe too.
Anybody? This is your last chance for commentary.
And our emails are on the slide too, so if you think of any questions later, feel free to.
Do you have a problem with the slides being distributed?
Not at all.
No, not at all.
Okay, so we'll probably distribute the slides and give everybody a chance to look at that.
Thank you, everybody. Appreciate your time.
Yeah, thank you all.
Thank you, Jeff and Garrett. Thank you very much for taking time out of your day to enlighten us. I appreciate it. Thanks for your preparation time, and thank you to all who are on the call. Just want to remind you, our next program is next week. It is going to be a pitch workshop, so please tune in. Thank you.
All right, take care.
Thank you. Thanks, Len, for setting it up.
Yep. Bye-bye.